this week's installment of the Center for Feminist Legal Studies lecture series, and welcome in particular to new faces that maybe we haven't seen this term at the lecture series, which runs every Tuesday at lunch hour in this room. And today I'm very excited to be able to introduce my criminal law professor, Donna Martinson, who went on to do bigger and better things than teach me criminal law, and who has recently retired from the BC Supreme Court, is here spending some time at UBC and elsewhere on a kind of sabbatical, looking at reforms to the court process in the area of domestic violence and family law. And so today she's going to present to us some of her work on violence against women and children and the BC Family Law Act. So I'm so excited that she's here, and we'll turn it over to Donna, and I hope we will have some time for questions and discussion.
As said, my topic today is violence against women and children and the new BC Family Law Act. I want to look at questions like what are the key issues and how does the Act address them, and what more is required to actually achieve effective change. But I'm going to take the liberty of providing some of my own personal reflections by using my own experiences to place the many issues that arise in an historical context. I'm going back one. Oops. There we are. Last year marked the 40th anniversary of my graduation from law school at the University of Alberta, and this year is the 40th reunion of my call to the bar. And my law class had a reunion celebration, the 40th, last October in Edmonton. In 1969, when we started law school, there were 14 women out of a class of 150, and that was twice as many women as the year before. And the women in the class were quite close, and it became traditional to also have a separate reunion for the women in the class. So as a result, 9 of the 14 women in our class found ourselves together just this past October at a Sunday brunch. So there we are. I haven't
very sensitive.
hang of this yet, but I will.
There we go.
So there we are. And this reunion was particularly significant as we were honoring and toasting our dear friend and classmate, Jean McBean, QC, who had recently died of cancer, and Jean is the woman on the end closest to me. She was really our leader in terms of advocating for women's rights at law school, and she devoted her career to the pursuit of equality for women. I also told them about an op-ed for the Vancouver Sun that I was in the process of writing with Professor Marjorie Cohen, called Who's the Judge? I told them that we had discovered that of the 31 judges appointed to the BC Supreme Court since January 1st, 2009, only 5 were women, and only 1 was not Caucasian, and that all of the 10 appointments in 2011 and 2012 were white men. Also, when that article was written, less than 4% of the judges on the court were not Caucasian, so this is last October, and less than 5% had a background in family law, though family law is a significant part of the work of the court. All the members of the BC Judicial Advisory Committee, including the judicial chair, were men. I think it's fair to say that all of us were shocked to hear this. The conversation turned to our experience at law school as women and the position of women then and now. We also, in our discussions, made a short stop to look at the situation 20 years ago in the early 90s, which for us was our 20th reunion. So I'm going to speak about some of the things that we remembered and discussed, and it's really just a snapshot of what was happening 40 years ago, 20 years ago, and what's happening now. So, going back to those early days in law school, as you can well imagine, there were no women profs, no courses relating to women and the law. An incident published in the Edmonton Journal following Jean McBean's death will give you a sense of our experience at law school. Her husband, John Wharton, was interviewed and described it this way, and I'm reading from that report. In those pre-feminist days, male law students would post pictures of naked women from a certain magazine on announcements of law school social events. The Christmas party poster put in the library might carry the full frontal nudity of Miss December. McBean and a handful of women decided that this should stop. When their request was turned down, they decided to fight fire with fire. But to find pictures of nude men was almost impossible in the pre-Playgirl days. So Jean, a young law student in her 20s, went on a mission to a less desirable part of the city. In an adult shop, she asked for photos of naked men, scandalizing the male shopkeeper who insisted she was in the wrong place. Jean then privately told a woman behind the counter what she wanted them for, and the woman quietly pulled out some photos held discreetly behind on a shelf. So back at the law school, the women students made new posters with the male photos and tried to post them. Of course, the article goes on, they were accused of smut. There was fury in the law school. But that was the last time nude photos of anyone were used. That's the end of the quote from the article. But Jean reminded me last year, shortly before she died, that a third-year male student at that time, one I might add, who happily supported the nude women photos, confronted her aggressively and told her that the photos had to be removed immediately as his wife was coming to meet him and she would be extremely offended. So, flash forward slightly to third-year law school. We did manage, with Jean's leadership, to get a course on women and the law on the curriculum. It may have been the first in Canada, but it was certainly one of the first. Only women took the course, and it was considered by many men to be just an easy course that women used to increase their grade point average. It was taught by Kathy Fraser, who, as you may know, is now the Chief Justice of Alberta, and I saw that she's speaking at the Women and the Law dinner later this month, and I really would encourage you to go and hear her. In third year, we were looking for articles, and it was very hard for women to get an article in position. We had lots of questions like, can you type, will you have kids? And we were told things like, we have our woman, or we had one once and she didn't work out. And many of us were turned down at a time when it was much easier for men to get a position. So, here we were. This isn't quite our law school photo because we don't have one that early, but it is an earlier one than the one I showed you before. We were incensed at the reaction to our applications for articling. Have you found me yet? Particularly since the women in the class had done particularly well academically and wanted to do something about it. So one of the women in our class, now an Alberta judge, wrote a song to the Melanie tune, which some of you may remember and some of you may know about. I got a brand new pair of roller skates. You got a brand new key. And our song, was, I got myself a brand new law degree. Have you a job for me? It had a chorus. I couldn't sing then, and I can't sing now. So, but it was something like, I got myself a brand new law degree. Have you a job for me? I can do the work as well or better than anyone you'll see. I've been looking around so long, won't you please hear my plea? Oh, I got myself a brand new law degree. Have you a job for me? We decided to sing this song at a bench and bar dinner at the end of our 3rd year that celebrated the graduation of our class. The people there were mostly men. Up we went as a group to the front of the room and started to sing our song. Though through most of the song, we got mostly strange, bored stares. But the last 2 lines definitely caused a collective gasp that we could hear when we finished the 2 lines and began singing the rousing chorus. And here are those 2 lines. You have to bear with me one more time. I got my law degree to practice law and try my luck. I didn't get it just to cook, clean, and pack. So, we have sung that song at every reunion, equally badly. But to be more serious, we felt we were bold and empowered and thought then that we could go out and change the legal world. And as you will know, it was a world in which there were no women judges. The first Alberta Supreme Court judge was appointed in 1979. And it was definitely a sea of white faces. With respect to family law, our topic here today, it was viewed by most as not being real law. It was not a course, and there was a strong view that if you were a woman lawyer, you should be doing family law and nothing else. It was often referred to as the pink ghetto. And in our reflections last October, we were reminded of our concern that while we were at law school, at the way in which women's interests had fared in this legal world led by white men. Violence against women was viewed as a private matter dealt with within the family, and if there were prosecutions under the criminal code, they weren't dealt with by the criminal courts, but in family courts, not really viewed as a real crime. And very significantly was the fact that a husband could legally rape his wife. There were issues with respect to women's credibility, and myths and stereotypes developed over many years by men to protect women. You'll know about them. It's dangerous to convict on the uncorroborated evidence of a woman, the law of recent complaint. I remember having it emphasized to me many years ago by my friend Christine Boyle, who I'm happy to say is here, that there was a textbook back in 1940 that was still being referred to at the time that I went to law school that emphasized the need for the corroboration requirement. And she recently reminded me that there have been others much more recently who have expressed this same sentiment, that this was Wigmore's observations, which are these, as you can see. Modern psychiatrists have studied the behavior of young girls and the women coming before the courts in all sorts of cases. Their psychic complexes are multifarious and distorted. One form taken by these complexes is that of contriving false charges of sexual offenses by men. With respect to financial matters, back then, women had essentially no property rights. Their unpaid work within the home, their role of mother and homemaker, was either ignored totally or devalued. There were no rights in cohabitation without marriage arrangements. Spousal support was extremely limited. With respect to custody, There was a misconception that, well, women may have been discriminated in some areas of the law, that they are and have always been favored in custody cases, and that's just simply not true. In the late 19th century and early 20th century, fathers were almost always awarded custody. In the middle of the 20th century, some male judges developed a doctrine that came to be known as the tender years doctrine, and in fact it was developed by a particular judge in the Ontario Court of Appeal in the case called Bell and Bell. And this is what it said. That's not looking good, but I can easily tell you. There we are. Instinctively, a little child, particularly a little girl, turns to her mother in her troubles, her doubts and fears. In that respect, nature seems to assert itself. The feminine touch means so much to a little girl. The frills and the flounces and the ribbons in the matter of dress. And it goes on to say, the whispered consultations and confidences on matters which to the child's mind should only be discussed with mother, the tender care, the soothing voice, all these things have a tremendous effect on the emotions of the child. This is nothing new. It is as old as human nature. Our friend Jean McBean did a lot of work in this custody area, writing a seminal article called The Myth of Maternal Preferences in Child Custody Cases. She noted that judges generally reflected mainstream attitudes, and while you may or may not agree with these general propositions, the problem was this, that the doctrine, the way the doctrine was applied, shows how judges accepted stereotyped, biologically mandated roles for women. For example, Jean pointed out, if a woman left her child in the care of another person to work outside the home, even for a few days or a few hours a day, she was criticized and couldn't rely on this maternal preference from a judge in the event of a custody dispute. This occurs, she said, because judges saw women as mothers only, not complete human beings with other facets to their lives. So I have this picture again because this was actually taken at our 20th reunion, and I have fast forwarded to 1992 time frame. And as you will know very well, many laws had been formally changed then as a result of the charter, often becoming gender neutral. However, deeply ingrained views about women, their roles, and their credibility that had informed the law so pervasively and for so long, of course, don't change overnight. And for the most part, a gendered application of the law continued. Justice Bertha Wilson, who, as you know, was the first woman judge on the Supreme Court of Canada, said it best in her famous lecture, Will Women Judges Really Make a Difference? Speaking in 1990 and pointing to relevant studies, she bravely said that there was overwhelming evidence that gender-based myths, biases, and stereotypes were deeply embedded in the attitudes of many male judges and in the law itself. My women classmates and I agree when thinking about that time frame with one legal academic who is now a judge who was speaking about family law around that time frame. And she said that continuing this created a new stereotype for women, the superwoman who needed little support for herself and her children. And as you can see, she described the fact that from her perspective, we agree persistent societal myths appear to influence the perceptions and responses of some judges in family law cases. Myths that have introduced that new stereotype of the superwoman, a woman who can return to work outside the home anytime and at any age, a woman who can give her all to her career while juggling 2 kids and a dog. And I think that's basically what was happened from my perspective. It felt like, you want equality, babe, you've got it. And, support orders for women and children continued to be dismally low, and all this resulted in what has been accurately described as the feminization of poverty in the 80s and 90s, leading to what was described as a new class of poor, divorced women and their children. With respect to custody cases in that time frame, several problems arose. Again, the lack of acknowledgement of women's parenting roles, the continued indifference to violence against women and children with its power and control issues, and the fact that violence against a mother was thought to be irrelevant to parenting. Here in BC, this led a group of BC advocates for women's equality to publish in 1996, as you may know, a well-researched, insightful book outlining the problems, aptly called Women and Children Last. Our own Professor Susan Boyd is, as you know, a well-recognized expert in this area. She, in that time frame, looked at working mothers in the 1980s and tells us that one finds an absence of discussion again of primary responsibility for parenting and an attendant inclination to overemphasize fatherly involvement in child care and the overall tendency to penalize working mothers for the perceived instability of their lifestyles. She described something that all of my classmates, when we were talking about this, completely agree with. A man with a full-time job who provides any assistance in child rearing, however limited, looked like a dedicated father, while a woman with a full-time job who still does primary but not all caretaking looks like half a mother dissatisfied with the child rearing role. We noted still back 20 years ago that family law was still not viewed as a serious or important area of the law. I, for example, can't tell you how many times I've seen family cases, including custody cases, postponed from court lists because there was a criminal case scheduled, no matter how minor that case was. So our discussions turned to women in the legal profession then, and we were really discouraged to find that though many women were attending law school and becoming lawyers through the 70s, 80s, and early 90s, many did not find the profession to be a welcoming place. This led, among other things, to a comprehensive report, again by Justice Bertha Wilson in 1993, called Touchstones for Change, Equality, Diversity, and Accountability. This is the last point before we move to today. In 1994, Justice Rosalie Silberman Abella, who, as you know very well, is now a member of the Supreme Court of Canada, spoke about the position of women then and outlined the many achievements obtained by some women. The women in my class knew we were among those achieving women, having been middle-class white women who had the advantage of being able to go to law school and also a 20-year career behind us as lawyers. But we also agreed with her view about how most women were faring then. Justice Abella said this, but for every woman in the thousands whose glass ceiling has been melted, shattered, or raised, there are women in the millions who think a glass ceiling is just one more household object to polish. she said there is still a huge gap between what the public thinks has happened to women, because several thousand have had the luck, guts, finances, friends, encouragement, or supportive partners to break barriers, and what is really happening for the majority of women. And she concluded by saying that these women are waiting for equality to hit home. They are waiting for the rhetoric of equality they hear to turn into the reality of equality they can live. So, fast forward for the last time to today. In my view, what Justice Abella said almost 20 years ago in many ways still applies today. Much good work, of course, has been done by many women's advocates since then to keep women's equality issues at the forefront. They contributed significantly to the content of the new Family Law Act and deserve significant credit. In the short time that I have, though, I want to discuss some concerns that I have that relate directly to the ways in which the implementation of the new Family Law Act must move forward if they are to be effective. And I know that my female law school classmates would agree with me on these. And I'll just touch on four: the role of family law, custody cases, access to justice for women, and women in the legal profession. So the role of family law. As Marjorie Cohen and I said in our Who's the Judge op-ed, the assumption among many members of the legal profession seems to be that family law still is not a serious branch of the law, but something that is more intuitive, not requiring particular legal expertise or skill. Just last Thursday, I was presenting a half-day session with a number of other people on the family violence provisions of the new Family Law Act at a lawyer's education program. And the keynote speaker was Jerry McHale. He expressed a similar view to ours. He said that regrettably, family law is still viewed by many as a poor cousin to other areas of the law. I'm told that there is less and less interest in the subject at law schools. With respect to custody cases today, I am concerned that too many judges and lawyers are encouraging joint parenting with little or no information in any given case about whether there has been violence against a woman or the children. There seems to be a lack of understanding on the part of many about the broad nature of family violence, its impact, and the implications that it has for future safety, security, and well-being, and on the related issue of post-separation parenting. There is still a view out there that violence against a mother has nothing to do with the father's ability to parent. Violence against women, of course, remains a significant societal problem. Many lawyers and judges don't seem to recognize this. I have too often heard them say in the recent past, some of them say in the recent past, that none of the cases they deal with involve violence. Women who raise the issue of violence still run the risk of being wrongly accused of attempting to alienate the father from the children. Access to justice for women. We all know about the devastating cuts to legal aid which significantly and negatively impact upon women. Effective legal assistance is needed to both help individual women and to continue to develop family law legal principles which reflect women's rights to substantive equality. And then finally, women in the legal profession. And I know that there are many other issues. For many women, the legal profession is still not a welcoming place. It's not good enough that some women do very well some of the time. The BC Law Society recognizes this and is trying to address it. And I have mentioned the fact that no women are being appointed to the British Columbia Supreme Court, and in fact the two appointments after our op-ed in October were both white men. Which brings me, finally, to the provisions of the New Family Law Act. And you will form your own views about their benefits. I think that it has lots to offer, and taking into account what I've said, where we need to go from here. As I see it, the New Family Law Act has two broad, laudable goals. One is a preference for out-of-court resolution of disputes, and this is one that gets the most play, and it is important, for sure. But it has a second and equally important goal, and that's protection from the adverse consequences of family violence. And I have been arguing that the goal of encouraging out-of-court resolution by agreement cannot be implemented at the expense of the goals of ensuring safety, security, and well-being and reaching fair agreements. The legislation only supports out-of-court resolutions which are fairly negotiated and which take into account the family violence framework found in the legislation. There are provisions in the Act about conduct of proceedings which say that judges must minimize conflict and promote cooperation, but I emphasize it's only cooperation which is appropriate, and that becomes significant. And also they must provide protection from protect children and parties from family violence. Among other things, judges must consider the impact on the child, which is very important, and minimize the effect on children of conflict. The moving to the best interests of children test. The best interests of the child is now the only consideration. It used to be the paramount consideration, although under the Divorce Act it's been the only consideration for many years. It's important to mention that the obligation applies not just to judges when they're hearing cases, but also to the parties. So if parents are considering reaching agreements outside of the court, they have to consider this framework. And the overarching direction is that an agreement or order will not be in the best interest of a child unless it protects to the greatest extent possible the child's physical, psychological, and emotional safety, security, and well-being. The court must set aside agreements if they don't do that. The Act has a very broad definition of family violence. It includes, as you can see, physical abuse, sexual abuse, which is an area that's often overlooked in intimate partner violence cases and attempts with respect to physical abuse and sexual abuse. It includes psychological or emotional abuse, and you can see some of the examples that are used: intimidation, harassment, coercion, threats respecting other persons, pets, or property. Those are considered significant risk factors for future violence, and you can see the others. It includes, in the definition of family violence, direct or indirect exposure to family violence with respect to a child. And importantly, it sets out specifically that it doesn't include the use of reasonable force to protect oneself and others from harm. There are a number of significant best interest provisions dealing with family violence, and I'm using that word because it is the word that the legislation uses, although in our programming we're emphasizing that violence against women and children is the most serious and prevalent, although of course not the only kind of violence. So guardians and the court must consider the impact of family violence, and I emphasize the word must consider, impact of family violence on the child's safety, security, or well-being. Whether the actions of the person responsible for family violence may impair his or her ability to care for the child or meet the child's needs. Another important addition is must consider other civil or criminal proceedings that are relevant to the child's safety, security, and well-being. And another important provision relating to cooperation. This is intended to address, I say, this issue of people assuming without looking at the facts of a particular case that cooperation will be in the best interest of the children, and provides that it is, you have to consider whether it is appropriate, including whether it would increase any risks to the safety, security, or well-being of the child or other family member. And I will pause to say that in the vast majority of cases, people, both men and women, are able to make decisions about their children that are in their best interests, and cooperation works very well. And that's wonderful, but we're talking about cases here where that's not the case, where people are having challenges in terms of figuring out what is in children's best interests. The Act sets out some very specific risk factors that judges must consider: nature and seriousness of the violence, when the violence happened, how often it happens, whether patterns of coercive, controlling behavior are indicated after a consideration of psychological or emotional abuse. As you can see, whether family violence is directed towards the child. I'm not going to have time to go through all of these risk considerations, but they're important, and I know that you will have a look at them when you're considering these issues. Another important provision is that the Act deals with denial of parenting time and when it's not wrongful. And it provides that if a guardian reasonably believes that a child might suffer family violence, and I'm sorry, I'll just backtrack. I'm talking about when there's a parenting court order in effect that requires, in our case, a father to see the children at specific times, and the mother denies that parenting time. And this won't be considered wrongful if the mother reasonably believed that a child might suffer from family violence, or the father was impaired. And of course the question of reasonableness is the key there. The Act contains new provisions about relocation, which we used to call mobility, And notice of relocation is required, but there is an exemption if the notice cannot be given without a risk of family violence. I'm going to just skip over the use of the child to talk about the role of the child's guardian. The legislation specifically provides that there should be no starting presumption either about parenting responsibilities, which is the new regime under the Act, or parenting time when making agreements. So you can't presume that responsibilities should be allocated equally, or parenting time should be shared, or that decisions among guardians should be made separately or together. At the same time, though, another section says that that when parents separate, both parents will remain guardians, and that guardian can exercise all parental responsibility in consultation with the child's other guardian, unless consultation would be unreasonable or inappropriate in the circumstances. From my perspective, that section must just refer to the time between the separation and when a final agreement or order is in place. I think some others are viewing it as more as a presumption of shared parenting, but I think it has to be viewed together with the section that I just referred you to, and as I say there, the exception is significant in the context of the Family Law Act as a whole, and consultation that negatively impacts upon safety and increases risk would not be reasonable or appropriate. There are new provisions relating to family violence orders. They used to be called restraining orders. They can be, they don't just relate to parenting issues. They relate to protection of family members. And there are risk factors that are similar, though not the same, to the ones in the best interest provisions that must be considered as well. And I'll leave you to have a look at those, but they are important. If a child is involved, the court must also consider Section 85, which says that you have to look specifically at whether a protection order should be required for the child. Another important provision is the one that deals with what are sometimes called mutual applications for protection orders, where both a woman and a man will apply for a protection order. And there has been, perhaps practice is too strong a word, but I've often seen situations where judges will, when that happens, just say, oh well, we'll just make an order against both parents. This section requires judges to consider whether an order should be made against one person only, taking into account the history of and potential for family violence and the extent of any injuries or harm suffered and their respective vulnerabilities. I don't have time to go through all of the other provisions now, but I want to make these points. The legislation specifically requires lawyers and other dispute resolution professionals to assess for the presence of family violence in the cases that they have. Lawyers who act as mediators, parenting coordinators, or arbitrators are required to have a minimum of 14 hours of approved training in screening for family violence. Other lawyers aren't required to, at this point in time, to have training in how to assess for the presence of family violence, although the Law Society strongly encourages lawyers to take courses in screening for family violence. In my view, this kind of education is critical to an effective operation of the new Family Law Act, because if you end up having a huge focus on out-of-court resolution with little attention paid to these very significant family violence issues, we will be in trouble. Just a few final points. It will be apparent what I think needs to be done to move forward from what I've already said. There are some encouraging things that are happening, and here are some of them, and there are many more. Continued work by the many groups who support women's rights, too many to name. The work of the new Family Violence Office, the ongoing work of Mary Ellen Turpel and her group of people with whom she works, the Children's Advocate. There is an Access to Justice study being conducted by the Supreme Court of Canada that has many useful recommendations, including family court processes involving judges who have a specialty in family law, and importantly for our purposes, a real focus on family law programming at law schools. There's a federal, provincial, territorial task force looking at ways of improving justice in these cases. The work of the courts, there is the work of the courts to encourage the appointment of more women, Aboriginal lawyers, and minority lawyers. But you will know from what I've said that there is much to be done. And I have to say that it sometimes feels, for me at least, quite discouraging to compare where we are now and where we were when I started law school 40 years ago, though I realize that there have been many advances. However, I have been inspired by all the work that people, mostly women, do to continue to pursue equal rights for all women, often working off the side of their desks in spite of lack of support and other resources. I attended a national research conference hosted by the Frida Center for Research on Violence Against Women and Children, organized by Dr. Margaret Jackson, who also is here with us. And I felt really encouraged by the wise words I heard there by Elder Mary Charles of the Musqueam Nation, and she looked out at this group of people from all across Canada, almost all of them women, and just said in her soft but very forceful way, women don't take no for an answer when they know there is a better solution. And I also think of my friend Jean and her courage and her dedication to women's equality, and I'll end by referring again to the Edmonton Journal article about Jean. Jean loved opera and theater and the symphony, and she and her husband John donated a chair to Edmonton's new performance art center. It's called the Wingspear Center. And the Edmonton Journal says this, when they did this, Jean thought it was too ostentatious to have their names inscribed on their gift. Instead, she wanted to have the words, "Till we have built Jerusalem." Apparently, Windspear fundraisers were flummoxed. Was this lefty couple perpetrating some kind of hidden political message on their chair? The crisis passed, the article goes on to say, when a fellow lawyer explained the words from a well-known English hymn based on a poem by the poet William Blake. It was McBean's favorite hymn, and it featured prominently in her memorial service. And I have to say, as an aside, that my husband reminded me last evening that that lawyer obviously did not know that this was also a rallying cry for Tommy Douglas when he led the National New Democratic Party. Just want to go to the very end, which may take oops.
You're trying to go to your very last slide?
Yeah, I am.
Let me see if I can
Thanks.
use this.
That's it. That's what's
This one
here. There we are. So, Jean, in the context of the pursuit of equality for women, and speaking for myself and your other long-time sisters-in-law, I'm going to have a hard time saying this, we will do what you did so well. Continue till we have built Jerusalem. Thanks.
Well, thank you, Donna, for that really interesting overview of the new provisions in a really important context that I'm sure for many of our students was new and very helpful. So we have a few minutes for questions if people have questions for Donna about the Family Law Act. Donna is also a tap dancer, and I thought we should show your tap dance video maybe at the end. I recommend it on YouTube. It's Rasma Tap, right? Is that what you're? Yeah. So you can find that. There's feminist tap dancing as well. But so.
We could find it if they weren't.
Questions about?
Okay, Donna. I'm still on the Supreme Court level. I'm on Scott right now, doing a study week. But so, with the requirements that judges take into account family violence, how do you think that interfaces? How is the judge supposed to get that evidence?
That's a very good question. How do judges get the evidence that they need to make these decisions? Margaret and I have been talking to lawyers about this. I mean, we think, have two answers to that. One is that we think lawyers have an obligation to bring that evidence before the court, but we also think that, I can't speak for you, Margaret, but I think that judges also have an obligation to inquire about that kind of information if it's not being received. And I know that it's complicated in terms of how one does that, and I also know that there are people who don't want to talk about issues relating to family violence. So it's very complex, and I think it will be part of the ongoing discussion. Nancy, does that answer your question, Vicki?
Yeah, well, I mean, I think you know that I think with self-represented litigants that judges may be required to move from their adversarial role and to be more inquisitorial and asking questions. And it's not only a big change in culture, but it's a concern for judges to not appear too partial and to review those claims. And I'm just trying to imagine the trial with a self-represented litigant where the judge trying to be impartial then feels that they must say, well, by the way, has there been any violence in this family? Or how can a judge tactfully ask those questions?
I'm learning that there's lots of, I actually use the word training, but I prefer education. There's lots of education about effective ways that one might ask questions that aren't just were you beaten up? Or, Rosemary, do you want to comment? I'd say that this is Judge Rosemary Gallagher from the Provincial Court, longtime friend. I brought my friends so that somebody would recognize the tune. I got a brand new pair of roller skates.
Certainly I agree it's complex, but I really do believe we are moving into a new era of judging, where there is going to be a more complex participation. I don't know what the steps are, but I certainly think that I have a duty to understand clearly what's going on in a relationship. And so respectful ways of getting that information, I look at as part of my role. And I agree, I know totally, but I think there's a dance going on, and I think clear and present, authentic communication is where you are all going.
Well, in your court, and because in the Small Claims Act, you can ignore the rules of evidence, and it's my court, we have to obey them.
But you're both working under the family law.
Yeah, but now it's the family. But I mean, I think your court is better practiced in asking questions. My court is much more inclined to be, dull, stone-faced things, just let the play unfold. And I think it's going to be a bigger cultural change for us to try to.
And I wouldn't for a moment say I would have the tools to explain to you how to do it. And I agree there's a different culture. But I think getting families out of trial and into conference and taking care is a different forum for solving family problems. Because I think in trial, I don't actually think any family should be in trial, although high conflict, I understand all the significant issues, but I still think we need to be much more hands-on at my level of work. We need more user-friendly, because people really need help, and they are not represented, and that's why this law, which asks or directs lawyers, I think judges, to really be more hands-on.
Nancy, this is Dr. Nancy Bell.
I was going to say that in Scotland, where I've been living, when children are affected by these decisions and children are living in homes where there's violence, the court will sometimes appoint what's called a safeguarder. And a safeguarder is someone whose role is to try and determine a child's best interests and help the court figure out what the best interests are in a particular context. So a safeguarder will meet with children in their home and try to get a sense of both what children are saying about what's going on, as well as a sense of the family environment. And they, for the most part, I think they're legally trained people, but their role is to come to the court with that perspective. So I mean, in terms of culture and change, that's maybe an initiative for the future, but it's an example of what's happening in another jurisdiction.
There was a comment?
Well, I was just going to ask, I think it's already been addressed, but whether the new law can be seen or at least argued as giving judges this authority, because if family violence is such a big change to the legislation, and there's all this process built in that requires information, and it's mandatory, it says judges must do X, Y, and Z, then isn't there some authority then for a judge in your position to be more proactive? At least if it was going to appeal, like, I think that's an argument that could be made in defense of a judge's maybe perceived activism. Was that the statute required in answering Steve's question?
I mean, I think absolutely. It's just a bit, it's a big change.
Yeah.
That's all. It's a very big change.
And there's no funding, So a lovely idea, but a new person to come and give the court information. There is no funding, I don't think, at this point for that effort. So it is a really big issue.
So there's lots of exciting things going on in the world of family law, so I'm glad that all of you are going to carry the torch forward. Yes?
Yes, I'm not a legal student, but I'm in women and gender studies. Wondering with all of the cuts to access to like legal aid and that sort of stuff, how do we mitigate the sometimes very large financial imbalance and at least the perception that those of us outside of the law have that money wins?
It's a good question, and in terms of the question in its broadest sense, how can we get more funding available for women? There's lots of other people here that know about that much more than I do. In terms of this new legislation, one of the things it does is give judges some very clear authority to make orders as to who should pay for services, so that in families where there are resources, judges can and I think should be more proactive in terms of making sure that there's a fair division of costs in terms of services and that sort of thing. But I think it's going to take a lot of small political will and energy to move forward. Yes?
Last week we had a presentation that spoke to some changes that happened in Alberta with regards to how law enforcement deals with documenting issues of family violence, so that evidence is more readily available to the court systems. To your knowledge, has there been a move to incorporate a system like that in the British Columbia as well, or is it something that's talked about at all?
I don't know the answer to that. Professor Boyle or Justice Gray, do you know? It sounds like a good idea.
Yeah, specifically, like what they implemented, or at least my understanding of it, was that any time that there was a call relating to a domestic dispute, that there was actually a physical checklist that had to be filled out and then documented with the responding officer, and then that way, at any level of court, that was just expected to be made available if there were those concerns. And it sounded like a great system. It sounded like it was very
Dr. Jackson, are you able to help in terms of not so much what Crown is doing, but what police are doing?
Well, actually, certainly, that particular sidetrack approach has been considered, is being considered here by the RCMP. And obviously, the RCMP also have their own investigative guides that provide information. I guess the question is not perhaps of direct relevance here is, well, that information probably would be appropriate and inform criminal court, criminal law. Is it something that should also be informing family law and family court? And I think that's another whole issue about how communications make it facilitated with regard to that type of information for both courts. And I think that's a very good system, as far as I know.
Good question, good answer.
Because here it sounds like, from your experience on the Supreme Court, that often the family court has none of that information from the criminal file.
Yes.
Yeah.
It's a huge problem, which I didn't have time to go into today, but in terms of safety for women and children and other issues, one has the problem where there ends up being criminal proceedings, family proceedings, sometimes child protection proceedings, and they, as other people have said it, they just sort of move along in their own little silos and there's no exchange of information, and it's not only very ineffective, but it can also be very dangerous. So that's something that's being worked on. That's one of the issues that the federal, provincial, territorial working groups of the federal and provincial justice ministries are looking at. So there's lots to be done.
It's something I'm sure that lawyers and make sure that their clients understand, because I imagine many of them would go to court thinking, well, this is a court filing, it's, everyone has everything, right? You just touch your computer and it would all be there. And they might well be surprised, I'm guessing.
Yes,
Yeah.
right.